The job that really remains now is to flesh the skeleton out into an argument that best persuades a judge to agree with you and disagree with the other side. What you are really aiming for is a clear argument. Verbose and flowery language in long-winded sentences will not be clear, and as far as possible, write an active voice.
Now, how do you flesh an argument out in a clear fashion? Here's a system that you can use on issues as well as sub-issues.
Do you know the IRAC method of constructing an argument? You can learn more about it in my law's course on legal writing. But briefly, IRAC stands for Issue, Rule, Analysis and Conclusion. It is a simple system for constructing and organizing an argument. In this system, the first thing to do is to state the issue. What is the subject of disagreement between the parties that the judge needs to decide on? After that, state the rule or the principle of law that you think applies to the issue you have stated. After that, present your analysis of how the rule applies to the issue. You may have to state how the rule applies to a set of facts in the problem. And finally, based on this analysis, present your conclusion. That is, state that on the basis of your analysis, the judges need to decide that particular issue is in your favor.
Remember, the ultimate purpose of all your arguments is to get some relief from the judges. So when your arguments are put together, they should logically lead to the grant of relief.
Flow is simply something which the text has that makes it easy for a third person to read it and understand it almost as they are reading it. So that's what I mean by flow, and therefore it is imperative, I think, for you to have other people read your memorial and tell you whether they could understand what is being said. They may not know the facts and the judgments that are cited in the case, but when they read your case, as your arguments as you have written them down, it should be easy for them to understand what is being said, and it should be easy for them to understand why you are saying it or what the final point you're trying to make is. You should use simple language. You should have shortish sentences. I remember we participated in the WTO moot and we were told, the competition actually on their website had recommended that you shouldn't have sentences that are more than 25 words long. And that really does help, because otherwise you tend to begin mixing up ideas that have nothing to do with one another. And when you mix up the words in which those ideas are expressed, there is a chance that your thinking will also be muddled. So when you are forced to break things down, I think your thinking will also benefit from that, in that you will have more clarity in the way that you think about the different elements of your case.
Now, remember, you're making a legal argument. This means that your argument, apart from being reasoned correctly and simply, also needs to be supported by sufficient legal authority.
When you're fleshing an argument using the IRAC method, it is at the rule stage that you most need the support of authorities. You may also use authorities when you present your analysis of how the rule applies to the issue. This is where you use your research in your writing. To learn more about how to do this, please enroll in my law's course on legal writing. It is very important to substantiate your statement of the rule and how it applies to the issue with the best authorities.
Here, your understanding of the sources of law, their hierarchy, and their relative persuasive value is important, and you should rely on it to decide which authority you need to highlight. So prioritize and choose the best authorities.
As you substantiate your argument with authorities, it is also important to attribute these authorities as sources of law. While different moot court competitions may have different rules, authorities and sources are usually attributed through footnotes. So whenever you use in your arguments an idea you came across in your research, make sure that the source of the idea is properly attributed in a footnote.
This is especially important when you're stating the rule or a principle of law applicable to an issue or a sub-issue. Whether the source of the rule is a statute, a judgment, a bylaw, a textbook, or an article, remember that this authority has to be attributed in a footnote.
And if you are taking text verbatim from such a source or authority, that text should be used only within quotation marks, and the entire quote should be attributed to the source using a footnote. To learn more about the technical rules of citation, please enroll in my law's course on legal writing.
Finally, your argument needs to be structured properly. Now, since your argument developed from a skeleton that you have already thought about carefully, it probably has a good structure. But you also need to make sure that a judge sees that it has a good structure.
which is why it needs good headings and subheadings.
These headings need to be drafted so that they communicate the steps that your argument takes leading to the grant of relief. So this will probably correspond to your list of issues and sub-issues, but may have to be rewritten for this purpose. So that is how you construct an argument. To recap, here are the stages in constructing your argument.
First, understand what you want to persuade the judges about. What is the relief you are seeking? Second, look at your preliminary research to understand what the law requires you to do to get that relief. Third, prepare a skeleton of your argument that takes all the steps that the law requires you to do in order to get the relief. Make sure that this skeleton is both simple and logically sound. At this stage, you can reframe your issues and sub-issues and even rearrange them. Fourth, build your arguments from this skeleton using the IRAC system, making sure that you have sufficient and relevant authority in support of your argument. So that's how you construct an argument. Once again, remember that your arguments are not set in stone. You need to keep asking yourself and the members of your team whether you have constructed the best argument for each issue you want to persuade the judges about.
Regular discussions during your preparation will not only help you develop your arguments better, it will also help you gauge the gaps in your arguments and also predict the rebuttals those arguments may invite.
One important tip to keep in mind while constructing arguments is to try and build a skeleton for the opposite side as well. That will not only help you see whether your skeleton needs any additional steps, you will also be able to spot the possible flaws in your own argument.
Often, at least in the moots I've done, we've always had to prepare arguments for both sides. So you have a memorial which goes for the respondent and the applicant. And I think that makes the process easier because when you're already thinking of something from both sides, you know what the strongest points of yours are and how you counter them. And to think of an answer already because you can anticipate what questions are going to come your way once you're aware of what the weaknesses of your arguments are. So yes, for all problems, you do always formulate arguments for both sides.
Thank you for watching this video on creating arguments. Once you have constructed your arguments, it is time to draft your memorial. That's in the next video of this unit.